dialed 100 and called the police. Full stop. Her father-in-law and Munir Khan, residing in the neighborhood, had taken Ulfat B to the Silvani hospital, where Ulfat B died during treatment. Full stop. FIR Exhibit P1 was lodged by PW8 Makran Singh, and thereafter investigation was completed, charge sheet was filed, and on committal, appellant has sessions trial was conducted, and appellant has been convicted with sentence life imprisonment under section 302 IPC. With fine with life imprisonment and fine of 1,000 rupees with default stipulation of 6 months RI. Next paragraph. Shri Avasthi submits that appellant is innocent. Firstly, there is no motive attached to the appellant. Full stop. It is submitted that though it is mentioned in para 53 of the impugned judgment that Man Singh had suspicion over deceased Ulfat B of engaging in magic, etc., and he was personally hurt because he had lost her aunt a year prior to the incident, and since he was of the view that Ulfat B was the person involved in black magic, he had caused her death. But there is no suggestion given by the concerned district judge, additional session judge, to the accused in while putting questions under 313 IP CRPC. Next paragraph. It is secondly submitted that eyewitness account of Hamidan B, PW1, is a weak piece of testimony. She has not stated that she too was sleeping outside in the open courtyard. Full stop. Thirdly, it is submitted that size of injury is not corroborated with the MLC/postmortem report. He has placed reliance on the evidence of Dr.
PW6.
The size of the injury does not match with the seized weapon. Full stop. He has placed reliance on the evidence of PW6, Dr. Insaf, to suggest that since the seized X was not presented for query report, it cannot be said that the injury which was caused with the same weapon which was seized from the possession, allegedly seized from the possession of the appellant. Next paragraph. It is further submitted that the witnesses of seizure memo are hostile, and therefore the seizure memo being not a reliable piece of evidence, on that basis conviction cannot be recorded. Reliance is placed on the judgment of Honorable Supreme Court in Allah Rakha Habib Memon, etc. versus State of Gujarat in criminal appeal numbers 2828-2829 of 2023, decided on August 4, 2024, wherein relying on para 43 of the judgment, it is submitted that FSL report alone is not sufficient to hold conviction of an accused. Full stop. The ratio of law is that there should be some material corroboration. Next pair. Reliance is also placed on the judgment of Supreme Court in Subramania versus State of Karnataka 2022 live law within bracket SC 887, wherein parameters wherein relying on para 90, it is submitted that High Court erred in relying upon the strong motive for the appellant convict to commit the crime as one of the incriminating circumstances. and therefore it is submitted that there being no motive proved, comma, there are no incriminating circumstances, and FSL report alone being not sufficient to record conviction, comma, impugned judgment of conviction deserves to be set aside. Next passage.
सर ये 76 का भी हवाला दे लीजिए.
पैरा 76.
हाँ इसी में सुब्रमण्यम में.
Full stop. 90 लिखा था ना, वहाँ पैरा 76 का भी हवाला दे देना. He also places reliance on para 76 of the said judgment in Subramania, wherein it is held that within inverted commas, keeping in mind the aforesaid evidence, comma, we proceed to consider whether the prosecution has been able to prove and establish the discoveries in accordance with law. Full stop. Thus, placing reliance on these judgments, it is submitted that appellant is innocent. चलिए अब इसको लंच के बाद कंटिन्यू करेंगे. आ जाइए. हाँ बताइए. क्या हो गया? लंच के बाद नंबर आएगा ना. अच्छा 12 नंबर में लिख लीजिएगा. Shri Rajak submits that state has to file objections. This is first bail application on behalf of the accused. है? वही तो लिखा है कि state has to file objection. सुना तो करिए.
ये फर्स्ट है, इसके बाद 2 टेम्परेरी डिसाइड हो चुकी.
अपना ऑब्जेक्शन पहले में लगा चुके हैं क्या?
नहीं, कनेक्टेड में है.
क्यों बता रहे हैं आप?
आई एम प्रेइंग फॉर एडॉप्शन.
श्री मानस मणि वर्मा adopts objections filed in connected cases. Full stop. श्री रजक, ब्रजेश कुमार रजक.
हिस्ट्री उनको मिली.
हाँ, आपके कितने साल हो गए?
सर मेरा 3 साल 10 महीना हो रहा है.
अच्छा. Then she got up. Heard noise. Then she got up. Full stop. She had seen the appellant Mansingh wielding an axe and attacking Ahmad Khan has stated that Ulfat B, when he had reached the house of Ulfat B on being called by the Chowkidar, then Ulfat B was conscious and when he asked her, then she said that take me to hospital, and Mansingh had hit me with an axe. Full stop. However, this statement is not corroborated by PW1, that is Hamidan B, who was already present at the scene of crime and who is the eyewitness to the incidents. Full stop. Even this fact is not corroborated from the evidence of the concerned doctor. PW 6. In as much as Dr. Insaf has also stated that injured was brought in an unconscious condition. Full stop. Thus, such minor contradictions can be overlooked, especially when evidence of PW1, Hamidan B, has remained unrebutted. Prosecution has not been able to create any doubt. Defense has not been able to create any doubt as to her presence at the place of the incidents, which happens to be the courtyard of the house of Hamidan B. Full stop. Another fact is that her conduct and story appears to be very natural. She has admitted that she was sleeping with her kids in the courtyard. Full stop. When she heard noise, then she got up. Full stop. She had seen the appellant Mansingh wielding an axe and attacking deceased Ulfat B. Full stop. This fact is also corroborated from Central Forensic Science Laboratory report exhibit P20, in which it is mentioned that human blood was detected on items 1, 3, 5A, 5B, 6, 7A, 7B, and 7C, full stop. They are respectively blood-stained earth, blood-stained निवाड़, ब्रैकेट में लिखिएगा, ब्रैकेट में मत लिखिए, निवाड़, 5A is the T-shirt of accused, 5B is the pant of the accused,